Assalamualaikum and hi to our beautiful Madam Mazlina binti Ahmad Zayada and to all our fellow friends. My name is Danishan Amelda binti Muhammad Darmarash and my groupmates are Kairanisa binti Rose, Muhammad Haris Amani bin Mazlan, Nik Nurlisa binti Nik Haris, Nurhani Sabrina binti Najibullah and Nurul Aisyah binti Amran. Today we would like to present about the current issue on two topics which are in hard time, union as troubleshooter not troublemakers, and Industrial Court cited COVID-19 to deny wage revision in collective agreement dispute.
Assalamualaikum, my name is Muhammad Haris Amani bin Mazlan and I will start this presentation by identifying issue of our first topic, which is in hard times, union as troubleshooters, not troublemakers. As we know, because of COVID-19 pandemic, many businesses are struggling to keep their business alive. P. Arunasalam, the former trade union leader, say that retrenchment expected to affect 12% of employees because of the weak economy and job market. Because of that, trade union roles are more relevant than ever as they can help buffer the situation by ensuring those who are affected are not denied compensation but instead can be treated fairly and considered for re-employment. P. Arunasalam stated that retrenchment should be the last option for employer to keep their business. Union should negotiate a win-win situation for both employer and employee. Employer, at the other hand, need to understand that union try to help the employee rather than trouble the company. P. Arunasalam believed that the number of people losing their job will get higher and could also drive away investors from the company. Back days, unions were militant in pushing for their workers' rights and even hand in some of the government policies. However, today is different. The issue on today's union is they are fragile and weak. P. Arunasalam said that union has become fragmented and timid and expect MTUC to do everything. He also stated that some leaders should know when to step down as they had become too comfortable and lost touch with the situation on the ground. They are not up to any challenge, not progressive, and have done no research on how to improve as a union. To conclude the overall issue, union should step up for the right of employees and not just remain silent on the current situation. Many people lost their job following the pandemic, and this is the time that union should be the most relevant and fight for employee rights. That's it for me. Thank you.
My name is Nik Nurlisa binti Haris and I will explain about statutory law. We found that this article is mentions about trade union, where a former Deputy Secretary General of the Malaysian Trade Union Congress MTUC said that retrenchment are expected to affect 12% of employees, and he also stated that unions can help to guard the situation by making sure that those who lost their job are getting their compensation and treated fairly and will consider for re-employment. The union have to negotiate a win-win situation for both employers and employee to survive. Employers have the right to retain their business, but they should take care of their employees because if something wrong, union will fight for it and defend the employees. Therefore, employees will go to union first when something happened to them. Section 2 of the Trade Union Act 1959 defined a trade union or a union as an association or combination of workmen or employers whose job is in West Malaysia, Sabah or Sarawak. The goal of the trade union is to strengthen the economic and other interests of employees within the framework of the employee-employee relationship to make sure they are right protected and social reasons. Thus, through this article, we found that a lot of employees who have been the victims of retrenchment due to the COVID-19 pandemic have approached the union to help them to defend themselves from their employers. Employees will turn to the unions at the first indication of problem, because the goals of the union are to promote the industrial, social and intellectual interests of its member, to receive and retain equal and appropriate rates remuneration for its member, security of jobs and fair working hours and conditions, promote the content, social and educational well-being of members. Lastly, to encourage legislation affecting the right of members, in particular unionists in general. Hence, the trade union can help the employees who are being retrenched by their employers without receiving any compensation to protect their rights. As a members of trade union, they can fight their right and make sure the employees follow the law. But through this article, we find out that union have been fragile and weak. They should never be like that because union is the one who will help the employees. Thus, union has to be strong and willing to fight. When the trade union take the case of employees who being retrenched and did not receive any compensation, they can use the union funds under Section 50 of the Trade Union Act 1959, where they can use the union fund only to cover salaries-related expenses for employees of the union, expenses associated with the settlement of trade dispute, and compensation for losses resulting from trade dispute for the members. This will help the employees to fight for his right. The trade union will be responsible to take care of their members' welfare and make sure everything is okay. In addition, this article also mentioned MTUC. It is known as the Malaysian Trade Union Congress. When the trade union cannot fight for the employees' right, they can refer to MTUC. The MTUC is a trade union federation and is registered under Society Act 1955. The MTUC has been acknowledged as the representative of employees in Malaysia by government. One of the provisions of the MTUC is to advise and serve as mediators in dispute between members of affiliated unions or between such unions and their members or between the union themselves, with the consent of the party concerned. Therefore, MTUC will help any union who is in need.
Hi, I am Nuhani Sabina binti Najibullah, and I'll be explaining on compare and contrast of the legal issue between the article, which is in hard times unions as troubleshooters, not troublemakers, and also based on theories of what we have learned regarding the trade union. Based on Aruna Salam, who was once a Deputy Secretary General of the Malaysian Trades Union Congress, MTUC, he stated that unions could help to buffer the situation by ensuring that those who are X are not denied compensation, but rather treated fairly and considered for re-employment, as it is estimated that there will be 12% of employees who will be affected due to retrenchments. Based on what we have learned, a union is an organization that represents employees' interests to manage any issues such as wage negotiation, disciplinary rules, and working conditions, and it is also consists of wholly or mainly of workers of one or more descriptions. The main legislation governing trade union in Malaysia is the Trade Union Act 1959, and there are three types of unions, which include public sector employees unions that consist of the public service, statutory bodies, and local authorities. Second is private sector employees union that consists of national unions and in-house unions. And the last one is employers unions, which consists of a united group of employers. In comparing with industrial relations theory and the article, there is a statement made by Aruna Salam, which he said, employers may have the right to retain their business, but on the condition they do not victimize workers because we will fight for them, which means that employers cannot retrench their employees without any reasons as the last resort for them to keep their businesses afloat. He also mentioned that due to political uncertainty, some well-to-do companies might take advantage of the current slowdown to cut costs by letting go of staffs. Based on theory, the employer cannot dismiss their employees without just cause or being unfair towards the employees. Therefore, in order to settle the dispute between the employer and employee regarding the retrenchment, trade union will represent trade union members, which is the employees itself, to sort out the issue and negotiate with the employer for a win-win situation. Next, in this article, Aruna Salam also mentioned that unions were timid, where they expect MTUC to do everything. Aruna Salam said the labour movement needs to re-strategize, rebrand, and re-engineer itself. The Malaysian Trades Union Congress, MTUC, plays an important role in the industrial relations system, and it is not a trade union, but a society registered with the Registrar of Societies. In contrast to what Aruna Salam mentioned, where trade unions expect that MTUC will do everything is not supposed to happen, as MTUC function is to act as the spokesman for trade unions and advises unions on any matters for which they seek for assistance, not to do everything in behalf of trade union and the members. Therefore, trade union leaders must get together and come up with a plan that including dismantling in-house unions and merging with national movement, or otherwise they will remain weak and will be bullied by employer.
My name is Nurul Asha binti Amran. I will introduce the current issues on industrial court cites COVID-19 to deny wage revision in collective agreement dispute article. The article focused on recent industrial court award in a collective agreement dispute that used COVID-19 as a reason to deny any salary revision, setting a bad precedent for future negotiations. Another blow in the same decision was limiting the backdating of revised benefits to 6 months from the date the dispute was referred to the court by the HR Minister, although the collective agreement negotiations begin in January 2018. In the written decision handed down by Penang Industrial Court Chairman Dominic Selvam Pian Pergasum on November 26, the new collective agreement became effective only in July last year after the dispute was referred to the Industrial Court the previous December by former Human Resource Minister M. Kulasegaran. According to the Malaysian Trades Union Congress (MTUC), not only does this mean that the new terms became effective 18 months after the negotiations started, but the 3-year period of the collective agreement will now end in July 2023 instead of 18 months earlier. Sivanathan said Industrial Court's decision to deny employee salary and benefits is dangerous as it can be taken advantage by other companies that will also try to deny their workers salary and benefit. In this case, although the Industrial Court's decision is understandable, this issue could have been avoided if the chairman had examined the documents to verify if the company had indeed suffered as a result of COVID-19. He also should have included a clause in his written judgment requiring the management to go back to the union for renegotiation as soon as the COVID-19 pandemic is controlled and business is back to normal. Current issues in the article. Firstly, the denied salary revision. As the union stated, the Industrial Court denying any salary revision as the award in the collective agreement dispute between the Northern Electronic Workers Union and Panasonic Automotive System (SDN-BHD). This will serve as a bad example for any future negotiations regarding the salary revision. Lastly, the aftermath of the Industrial Court's decision. Other companies that has the same intention to deny their employees salary and benefit will utilize this decision and use them at their advantages.
Assalamualaikum and hi, I'm Danishan Emelda. Now I will continue explaining the statutory law. According to this article, the statutory law applicable for this case is Industrial Relations Act 1967 under the collective agreement. This is because in this article, it mentioned that the union and employee are not able to settle their claim of the collective agreements since there are new terms become effective 18 months after the negotiation started, where this issue started to occur as Industrial Court had agreed with the new terms even though they didn't receive the mutual agreement from the parties. There are 5 items that are commonly found in collective agreement, which are recognition, union security, compensation and benefit, existing benefit, and procedures. According to this article, the first legal issue is about there is a collective agreement dispute as they use the COVID-19 issue as a reason to deny any salary revision, where union believe that this will also affect the future negotiation. This issue can be seen under compensation and benefits. The second legal issue will be under a procedure, which is about the workers are feeling upset about limiting the backdating of the amended benefits to 6 months from the date of the dispute was appealed to the court. This leads to employees could only get the benefits of 6 months even though the negotiation had begun in January 2018. Furthermore, the third legal issue is about the Northern Electronic Workers Union and Panasonic Automotive Systems Sdn Berhad facing the problem of not being able to settle their claim for collective agreement, which required them to force the Penang Industrial Relations Department to refer this matter to the minister so that the minister can send it to the Industrial Court. Regarding this case, if a dispute on the collective agreement is not resolved, according to Section 26(1) of the Industrial Relations Act 1967, the minister may refer the dispute to the Industrial Court on a joint request in writing by the trade union and the employer, or according to Section 26(2) of Industrial Relations Act 1967, upon receipt of a notice from the Director General of Industrial Relations (DGIR), refer the dispute to the Industrial Court. If it is satisfied, then it is reasonable to do so. Next, what is collective agreement? A collective agreement is known as an agreement in writing between an employer or a trade union of employees and a trade union of workers relating to the terms and conditions of employment or the relation between the two parties. There are two ways where collective agreement could exist, which by the mutual agreement or through an award handed down by the Industrial Court under Section 26(1) or Section 26(2) of the Industrial Relations Act 1967. The agreement governs the relationship between the employer and workers for a defined period of time. If the employer refuses to comply with the terms in the collective agreement, any trade unions or employee can lodge a lawsuit with the Industrial Court.
Hi, I'm Karenisa Bentiros. Now I will explaining on compare and contrast the legal issue that has in Article 2 with the theory or legislation that we have learned in this subject. In this article, it stated that Industrial Court award in a collective agreement dispute that use COVID-19 as a reason to deny any salaries revision. So, unions say this decision that has been made by Industrial Court is a bad precedent for the future negotiations. This issue is related with the Chapter 7 and 8 of Industrial Relations subject, which is collective agreement and trade dispute. This issue is under misinterpretation of collective agreement. According to Section 33(1) of Industrial Relations Act 1967, if any question arises as to the interpretation of any award or collective agreement that the court has taken cognizance of, the minister can refer the question to Industrial Court for a decision on the matter or any party that bound by the award. Next, in Section 33(2) of Industrial Relations Act 1967, it is stated that if it finds it desirable to do so in order to eliminate ambiguity or confusion, the Industrial Court can request change some of the term of the award or agreement of the party. However, the parties are given a fair opportunity to be heard. So, this article, Industrial Court choose to change award in collective agreement and use COVID-19 as a reason to deny any salary because Industrial Court are considered with the current situation of COVID-19 and find it is desirable to do so in order to eliminate ambiguity or confusion of both parties. The Malaysian Trade Union Congress General Council member A. Sivanathan also agreed that citing the COVID-19 circumstances can affect such award during the pandemic. But he hoped the chairman should have included a clause in his written judgment requiring the management to go back to the union for renegotiation as soon as the COVID-19 pandemic is controlled and the business is back to normal. Next, A. Sivanathan also said this decision could be used irresponsibly by other companies as precedents and deny the workers the rightful salary increase. From what we have learned, there are a few settlements of dispute that can help the employees from being treated irresponsibly by companies. There are 4 procedures prescribed by legislation to settle the dispute between the employees and employers. First, bilateral negotiation between employers and employees. Second, conciliation by the Industrial Relations Department. Third, arbitration by the Industrial Court. And lastly, mediation. All these procedures prescribed by legislation will help to solve the dispute. Lastly, from what we have learned, we believe the court taken into consideration the interests of union and the company in this fragile economic condition right now. That's all from our group. Thank you.